Number 60, matter of Celinette H.H. versus Michelle R. Counsel?
Carol Kahn, attorney for Celinette H.H. The mother, Celinette H.H., dismissal of her enforcement writ without prejudice to refile as a custody petition when the COVID siege was over. I'm sorry. The mother appeals the dismissal of her enforcement writ without prejudice to refile as a custody petition when the COVID freeze lifts, to reclaim 3 children wrongfully detained by the father in South Carolina after overstaying a 3-month vacation. And the writ was dismissed without prejudice to refile the custody petition. The trial court ruled the mother lacked subject matter jurisdiction to file her writ because she never previously filed a custody petition. What we claim is wrong with this is that New York takes a functional approach to the foundation proceeding that will support an enforcement writ. For example, in matter of Miranda D., you didn't need a custody petition or even a visitation petition to create a jurisdictional foundation for a mother who was the respondent in a neglect proceeding to bring in an enforcement writ to enforce her right created by the neglect petition brought by ACS, which gave her supervised visitation in New York. What I'm saying is a liberty interest can be created in a petition where the person who has the liberty interest is not the petitioner. So long as they're a party to the foundation proceeding, their liberty interest can be created and can be enforced by a subsequent writ. In this case, it was not the mother who filed the foundation proceeding, it was the paternal grandmother. Now, the paternal grandmother originally filed a custody proceeding, which was converted into a visitation proceeding. And you have to look at the UCCJEA, which is an interstate compact to which New York and South Carolina are both signatories. And the UCCJEA says a visitation petition, as a term of art, is a first custody proceeding as to all the parties to that visitation proceeding. So in this case, there was a visitation proceeding in New York Family Court in 2018 initiated by the maternal grandmother. She initiated it as a custody proceeding. It was converted into a visitation proceeding. But whatever it was called, under the UCCJEA, it functioned as a first custody proceeding as to everybody.
Did it matter whether the father participated in that proceeding or not?
Yes, he was a party to it. I got to explain further. One of the problems with this case is the law is interesting, but the facts are very complicated, and you can't understand the relevant law until you understand this horrible mess of facts. And the facts that you need to understand are in the foundation proceeding, the visitation case. The rest of it is relatively straightforward, not too. In the visitation case, you have to look at 3 documents. You have to look at the visitation petition. You have to look at a stipulation between the mother and the maternal grandmother. And then you have to look at the consent order, which says there was an allocution to which the father was a party. Now, if you look, first of all, the petition in the prior visitation case says the mother and the children have lived at 140th Street in Manhattan for 9 years. The paternal grandmother also lives in New York. The father lives in South Carolina. The grandmother is seeking custody. She was originally seeking custody, and she converted her custody petition into a visitation petition. And the stipulation between the mother and the paternal grandmother is The paternal grandmother will pick the kids up at school in New York and deliver them to the physical custody of the mother every night she has visitation in New York at the mother's and the mother and children's residence. Now, this is established both in that stipulation and in the petition, the visitation petition. Now, the grandmother is acknowledging she's not getting custody out of thin air. She's getting it from the physical custody of the mother in New York, where the mother lives with the children for 9 years. And the father, in the consent order on the visitation case, he consented to this. He appeared and allocated, knowing what was the contents of this order. Now, that means many things. That means, number one, the mother had physical custody. Number two, the father appeared and was a party to that. Number three, New York is the home state, which has exclusive jurisdiction under Domestic Relations Law 76. Now,
Excuse me, can I ask you, is that what Judge Arias meant when she came on a call and said, I have a custody order here? Is it the visitation order?
That's what I'm saying. That was her shorthand way of saying there's a custody order here. And that's why she also...
Can I also ask you that, how did we know that that's true as opposed... There were a number of temporary orders of custody that had been issued at some point previously, or maybe, I don't know when, you can tell me when. But I'm just curious to know why we know that what Judge Arias is talking about is the visitation order and not something else.
The reason we know it is because she said to the father, I think it's about A33 to A35 of the record. She said, the mother has custody. She said, I'm granting this writ. She said, if you have safety concerns, she said, you can file a modification petition. And obviously, since the only petition that had been filed in the past was this so-called visitation petition, which under the UCCJEA is a first custody petition.
Counsel, I'm sorry,
Yeah.
Is your argument that that proceeding, which resulted in these visitation rights, resolved custody between father and mother?
Well, it resolved that the mother was the physical custodian and that the father, if he wanted to modify, he had consented to the grandmother's only getting 1 hour of visitation during a school week, and any other visitation in that same order was limited when they weren't in school, was limited to 1 hour.
Is your argument that then by doing that, he is conceding that mother has sole custody?
He's conceding physical custody to her, assuming that he has joint custody. In order to modify that relationship with the grandmother, he's got to come to New York and modify it.
So if those proceedings had never taken place...
Excuse me?
If those proceedings had never taken place, hypothetical, if they had not taken place and this proceeding was brought, could the judge entertain this habeas?
Well, the point was this. The mother filed her habeas petition.
No, but could you answer my hypothetical? So this is not this case, I understand. But if there were no prior proceedings, could the mother come into this courtroom with this habeas proceeding?
I think she could, because she would say instead that the father has to file a modification petition to establish what visitation he wants.
Well, let me try Judge Garcia's question differently a little bit. I look at DRL Section 70, and it seems to say that you can file a habeas petition without it makes no reference to any prior proceeding at all. It seems to say on its face that you can initiate a proceeding under habeas. So we understand,
Okay.
I think, at least I understand the argument you've made that turns on, right? But it seems to me you have a simpler argument that I do find in your papers, although not, it's not like in highlighted, but that the Domestic Relations Law, Section 70, and then you also refer, I think, to Family Court Act 651 and DRL 240.
Right.
All either together or independently give you the right to start the proceeding, even if there had been no prior order.
Okay, I'm happy to concede that, but I mean, my real concern in this case, and I don't want to jump ahead, but I don't know how much extra time I'm going to get, is that assuming the mother certainly has an enforcement writ because the father, the grandmother was not, the grandmother clearly under her visitation right from the first proceeding didn't have the right to leave the kids in South Carolina. And the judge in the middle of, in colloquy says to the grandmother, go down and get the kids. And the grandmother says, no, I think the father's a better custodian. So she was clearly in violation of her visitation order. But the judge said, if I put her in jail for contempt, I don't get the kids back. So at that point, the judge, anyhow, the judge on the writ was careful to serve him properly by a 3085 order for the only way she could reach him at that point, since he had cut off all contact with the mother. Oh, well, he violated the mother's right to custody by cutting off all contact. She couldn't get the kids back. So since he was a party to that first order, you know, her rights, and the children were still New York residents because they lived with her, and then they went south and they were there for 5 months. It takes 6 months to create new home state jurisdiction under the UCCJEA. Look at Domestic Relations Law 75A7.
But Counselor, as the Chief Judge just said, couldn't she just have proceeded with the habeas?
Well, the problem...
Regardless.
Yeah. The problem with the habeas, it's more complicated because I have the feeling that the trial magistrate who dismissed this case without prejudice dismissed it not because she thought really that there was a lack of subject matter jurisdiction for the habeas, but because she had been told that the South Carolina marshal would not enforce a writ unless she could establish emergency temporary jurisdiction to show that the father had been a dangerous father to the children. That's not necessary where there has been a wrongful taking. That's under 76C, and that's a whole nother layer. But one of the problems under the UCCJEA is that different states interpret it differently. So I think the reason why the trial judge acted, and the reason why it seems to me clear that the magistrate who dismissed the case knew that there had to be subject matter jurisdiction for the writ, was Judge Arias, who had conducted prior colloquy, had already said, the writ is granted, and a temporary custody order had been granted, and then it was revoked by the magistrate because the magistrate heard that the South Carolina marshal would not enforce the writ order, would not issue a warrant unless the mother could establish emergency jurisdiction under 73, Domestic Relations Law 73C.
Counsel, was your position in front of the family court that...
I wasn't the trial lawyer.
Your clients, was the position that we have what is in essence a custody order, we don't need anything else, we just want the writ? Or
Yes.
did you ask for custody, your client ask for custody determination?
Well, she did both. And the reason for it was because she felt that South Carolina would, if she got a custody order, she could then docket it in South Carolina, and South Carolina would have to
Did
honor
she
it.
ask for that order based on the prior proceedings, or did she ask for that order in a new determination of custody between the parents?
I think the idea was that under 103C of the CPLR, if you've got subject matter and personal jurisdiction under the writ, and the writ isn't the appropriate form of proceeding, it can be converted.
And where in the record is that your client asked for that in family court?
I know I cited it in the brief, I don't remember it, the citation to the record is there. I know it was her trial counsel who specifically asked under 651B that the custody order be granted.
And Counselor, what relief are you asking for from us?
Well, I would like you to do both. I would like you to grant the writ, but I would also like you to analyze this underlying problem that I think, what do you do when, and this happens a lot, the two states interpret the UCCJEA differently. In fact, there's a law review article, which I didn't tell you about, but you might like to read on your own, called Jurisdictional Boomerang, and it's about the problems with the UCCJEA because two states interpret it differently. So what I'm saying is, what good does it do the mother if you give her a writ and the kid is still in South Carolina at an unknown? I got an address from the police department, but they didn't give it to me under oath.
I'm sorry, Counsel, I just, a little clarity on this point about the analysis under the statute, under that particular statute. Is your argument that if there had been an order of custody in favor of the mother,
Yeah.
that the other jurisdiction would not have recognized that order?
No,
Put
no,
aside
they
the writ for
would've.
the moment, just the order.
They would have she could have docketed it as a custody order in South Carolina.
So what is it that Judge Arias did or didn't do that created an obstacle to the mother doing exactly what you've described?
Judge Arias got off the case, gave it to a magistrate to hold an inquest and issue a warrant on the writ because she felt that there was
So
jurisdiction.
Judge Arias issued the writ even though she was talking about custody and didn't sign an order of custody? Just to be clear,
Yeah,
how
there
you
was
see
a
this writ
temporary-
and what the judge did or didn't do?
Well, there was a temporary order of custody issued, and then Judge Arias said to the magistrate, send a notice of inquest, hold an inquest, and then issue a warrant. But the whole trouble was the magistrate never issued a notice of inquest. She then held an inquest, but it would have lacked due process because it says right in the record there was no notice of inquest.
So after that, counsel, it looks to me like the determination by family court was that your client had failed to file a petition for custody.
Right.
And could she have filed a petition for custody at that point?
No.
Why not?
Because this was during the COVID freeze, and there were 3 administrative orders issued by the chief judge of the family court and the 2 sub-administrative judges holding up all custody petitions until the COVID freeze ended.
And is that point clear from the record? I take it you're saying she couldn't have filed, after being told there was no pending custody petition, I take it you're saying COVID freeze precluded her from doing that. Is that point?
And then about a month later, she was able to file, but when she filed her writ petition, the COVID freeze was in effect and she could not file.
But after she was told that...
She did file, but the problem, and the idea was, even though this writ was dismissed without prejudice, I'm saying she was prejudiced by the dismissal because in the writ petition, she got both personal and subject matter jurisdiction over the father. He appeared, testified,
But just so...
and then he just, dropped the phone. But she couldn't get personal jurisdiction over him when she refiled the custody proceeding because he disappeared.
Thank you,
So that's
counsel.
why she was prejudiced by the dismissal of the writ without prejudice. But what I'm saying to you is, I don't know that she's going to be benefited if you just grant her, if you say it was wrong to dismiss the writ because functionally the prior visitation proceeding really was a first custody proceeding to the mother. That's not going to do her a whole lot of good to get the kids back from South Carolina if the South Carolina marshal won't enforce her writ, won't enforce the warrant on the writ without proof of temporary emergency jurisdiction.
Okay, thank you, counsel.
Okay, thank you.
Counsel, you may want to stay for the balance of the argument. That's all right.
May it please the court, Philip Katz, the attorney for the children. Your Honor, I think while Ms. counsel's arguments are compelling, I think, as it was alluded to by the court, it's a lot simpler than that. This is a case where there was my clients were living in New York for years. They go on a visitation based on a visitation order in 2020 in the summer that was issued to the grandmother, the paternal grandmother. Grandmother takes the children to South Carolina to visit their father, doesn't return them. That's when counsel's client files her writ petition. That writ petition absolutely, without any regard for whether there was a prior custody order or getting into the semantics of any of that, under DRL 70, instilled within the court the right, the jurisdiction, to issue a writ. And in fact, it did issue a writ. But over the course of a year, as you've heard and you've seen in the record...
The
Yes.
court issued the writ after stating that there was a underlying custody order. Apparently, you would think aware of what the current First Department law is on that issue. And I certainly don't, did the mother ever argue to the family court, it doesn't matter that there is or isn't a custody order?
So I was there, and I don't recall that, and I don't see that in the record. But I don't think that's necessarily relevant to the issuance of a writ. I think...
Counsel, is your argument that the writ issues for the violation of the visitation order? Is that what?
No, what I'm saying...
Let's say you have a couple. They have joint custody. One spouse takes the kids to New Jersey for a week and goes to the shore. Can the other spouse go in and get a writ?
So the answer is, arguably, yes, the court has the power to consider that. Absolutely, the court has the power to consider that, and the court should consider that. Of course, Your Honor has certain facts that make it obvious that it's not appropriate in that case.
But what's the, as I understand it, and I think Section 70's title, what's the unlawful detention there, right? We have joint custody. The couple has joint custody. The one spouse takes the kids to New Jersey for the week to the shore. And what would be the authority under habeas corpus for child detained by parent to issue a writ?
So the facts that Your Honor are describing, I still would argue the court has the right to at least consider it and make sure those are the facts.
Let's say there's an argument that that's not a good result.
Right.
What would the distinction be?
The distinction here is that the court is aware from the history, at the very least, that these children were living with their mother. Forgetting about whether there's a valid custody order, a visitation order, or whether the visitation order should be considered a custody order under the UCCJEA, I submit to the court that that's not really what the analysis is.
So in essence, you have to come in and prove you have custody and in one way or another, and isn't that asking the court to make a custody determination?
I don't think you have to prove you have custody, Your Honor. I think the purpose, my ask of this court is to consider the court's power of issuing a writ under DRL 70, its power to protect these children under the doctrine of parens patriae, is one where the court is obligated to take a look and see if these children are safe. And this court didn't do that. It failed to do that.
But you have an interstate component here, and I think counsel alluded to that, and we have some issues with enforcement, which I'm concerned about, and I feel like I don't have a good idea about from what I've read. What would the effect of our New York's enforcement capability, a New York family court judge issuing a writ like that in South Carolina, right? I mean, without a custody determination.
So let me say this to Your Honor first in sort of answering that question. I was reading recently a study, and I'm sure this wouldn't be a surprise in terms of these numbers to this court, that was done by Columbia University and an organization called Robin Hood. It's a 2017 study that finds that in the city of New York, there are 250,000 single-parent households. And in those households live approximately 580,000 children. So they're coming to these family courts every day with these types of situations. There is a mother or a father who's been taking care of a child or children for years. If the other parent wants to come in and just take that child out and walk into another state with those children, as far as I'm asking this court should tell every court beneath it that it should take a look to make sure they're not detained. Issue the writ.
Let me ask you a question. My understanding generally of the writ of habeas corpus is it's a command to bring the body of a person to the court.
Correct.
That's what it is.
That's all it is.
It brings the subject of the writ in front of the court.
Correct.
The court from that point needs some other vehicle if it's going to determine custody or whatever, but the purpose of the writ is just to bring the person.
That is correct.
So as I understand Judge Garcia's hypothetical to you out in the Jersey Shore, let's say my wife takes the kids there and I don't know about it, I could come to court and say that. The court might well deny the writ on his facts, right?
Sure.
If it granted the writ, that doesn't mean that I would get custody. It means it would then have a determination about that problem.
That's right.
Likewise, if my wife instead, which she would never do, took the kids to Chile and didn't return for a year, and I filed the writ, I would hope I would get a somewhat different result. And as to the interjurisdictional, in that case, Chilean problem, you'd have a real problem with service, but in this case, the defendant had appeared. And so you don't have a problem with service.
That's correct. There's absolutely no problem with service. In fact, the defendant just hung up the phone when he didn't like what he was hearing. And that's exactly what happened.
Do you think there's what does Section 71, it says detained, but Section 8 says where a minor child is residing within this state, right?
And that's another good question, Your Honor. So, and I've provided some case law in my letter brief, where a party takes a child outside of the jurisdiction. This court has said, in fact, I think I referred...
Because, just to back it up, the problem I have with comparing a writ, a habeas writ, to just bringing someone to court, I mean, that's kind of like a subpoena, and I guess if you're within the state, no harm, no foul, court has jurisdiction, everyone come to court, where you're dealing with another sovereign, South Carolina, they're going to look at what you've done. And they may take a very different view of, use this like a subpoena. So don't you think we should consider New York's enforceability rights and the way states look at what we're doing here when we issue a writ and whether or not they're going to honor it when we make a determination of what you need to get a writ in the first place?
Well, that's a great question, Your Honor. And I think that DRL 70 is a UCCJEA supported statute. And in fact, if the defendant father had a concern, he could very well have gone to the court in South Carolina and filed something, and then there would have been a UCCJEA conference. It happens all the time. And then it could have been reconciled. But he didn't do that, which should have made this court in New York more worried about what was going on. You have a defendant who hangs up the phone. You have a history of a case where you have the mother who had these 3 children in New York for years. Father conceded as much when he consented to the order giving the paternal grandmother access, returning the child to the mother at the end of the access. So this is not the Jersey Shore example.
What happens as a practical matter? I take it from your brief, you are of the view that the children are still in New York State for purposes of DRL 70. Okay.
true.
And so if, as your response to the Chief Judge indicates, the function of the writ is to secure the children physically, bring them to the state, I take it that first of all, you have to figure out how to enforce that vis-a-vis the South Carolina authorities. And secondly, once the child gets here, if the enforcement is viable, does then a custody determination need to be made? I take it from your answer to the Chief that the habeas proceeding itself is not dispositive of a custody dispute.
Correct. The habeas position, Your Honor, is not the conclusion. It's the start.
So how do we know, and this goes to Judge Garcia's point, I think, that whether South Carolina will in fact respect a DRL Section 70 order and assist in the return of the children to the state if the order were so issued?
So I believe, and this is, again, just my understanding based upon the facts of this particular case, that the problem with getting the order enforced in the first place is that it was a temporary custody order. And I think that was something that was difficult for counsel's client to get enforced because it was a temporary custody order.
But you think a habeas writ would be enforced even though a temporary custody order would not be?
So I think a habeas writ will either be enforced, or at the very least, it could be domesticated and considered there. I don't think the courts of this state should not act because they're concerned about what another state will do. This court should focus on what's best for these children. That's
Do you
this
agree with
judge's
counsel
job.
that that's what stopped the referee in this case, the intimidation by the fact that South Carolina wasn't going to enforce
I don't
the
believe that
order?
at all. No, I don't believe that at all. I mean, there was a combination of things. I think we heard about COVID. We heard about fatigue. I think it was some fatigue with this case. I think it was a bad decision, and that's, I think, why we are here.
Well, I may have misunderstood. I thought the point was that they didn't think that the mother had a custody order. And she's got to go file for that so they can determine whether or not she should have custody
So
versus the father.
it's
legal and
fair to
physical.
point that, Your Honor, that was said, but I'm in those family courts every day, and that's not how it works. When you're in those family courts, if a child is brought in pursuant to a writ, they're able to talk to their attorney, which these children weren't able to talk to me at that time. I've spoken with them previous to that and post that, but at that time, their father kept them away from me. They talked to their attorney. Then the court exercises its parens patriae authority and responsibility to make sure those children are safe. And that may be directing a party or both parties to file custody petitions to figure things out.
Counsel, I need to ask before your time's up.
Yes.
This is a fascinating discussion about what the jurisdictional predicates for a writ are and whether it would be enforceable or not. Why wasn't any of this passed upon at the appellate division? I'm trying desperately to understand why the appellate division dismissed the appeal.
I cannot.
You can explain too, but I want to hear his.
I cannot explain why it happened. I mean, it's disappointing that it did happen, but I cannot explain why it happened. I
Well,
honestly can't.
it seems, based on your prior answer, that they don't see the practicalities the way you do, right? They're saying you've got to have a custody order before you can go about the business of demanding that these children be brought back to New York.
And I think, I mean, I could.
Maybe that's right, maybe that's wrong, but that seems to be the appellate division's,
Maybe
the
they
law
were
they've
focusing
developed.
on DRL 76, not on 70. And quite frankly, if you're looking at DRL 76, I do not think this court should rule in a way in this case that sends the message to the lower courts that custody is simply an order. It's not simply an order, there are facts.
Well, would
that have to
all
be
of this
involved.
have been avoided if at the point in time when she's filing the writ or at some point during the various appearances before Judge Arias, at that point she files a petition for custody? Would it have perhaps avoided some of this, given the appellate division's law?
So I do not have a crystal ball. It may have. It very well may have. But it shouldn't have been dispositive, is what I'm saying to you.
Thank you, counsel.
Good afternoon, Your Honors. My name is Jeffrey P. Berman, and I represent the respondent, Mr. Willie R. Yes, I think it's absolutely accurate that the main issue here is the interpretation of domestic relations law, Section 70. And the question, on its face, the statute says that either parent can apply for a writ. However, both the First Department and the Second Department have interpreted it to mean that there has to be a prior order of custody in place to give the parent a greater right to the custody of the child. So, for example, as Your Honor said, one
But
parent
where in
can't
the
go to
law
New
is
Jersey.
that required? I understand you're saying that's the way they've interpreted it. Where is that, if that's not what the section says, what's the hook for that?
Right, so the statute is silent on that, and the departments have said that, I think their reasoning, while they're not long decisions, they do say that the one parent has to have a greater right to custody than the other, which would be set forth in a order of custody.
So historically, when the writ of habeas corpus was used in England, and one parent, let's say, was seeking to, it was used a bunch of different ways. For example, sometimes a child who had been married to somebody, the parents then claimed that that was, marriage was unlawful, the person had been abducted, and would use the writ to try and, I mean, there's no prior order in those cases, right?
Right.
So historically, I don't see any requirement that there be a prior order for invoking the writ, where, at least as I understand it, the writ is just to bring the body to the court. It's not a decision, it's just bring the body to me. And you do have to make a showing,
Yeah.
right? But I don't think the showing has to be that you have a right by a prior order.
Yeah, I mean, that
So
could be.
if that's historical practice, and then our statute doesn't have that requirement, but you're saying the appellate divisions have engrafted it, why should we follow that?
Yeah, and I agree to a certain extent. I think one of the cases cited by Ms. Khan, the one from I think 1976 maybe, the first department, they didn't require a prior custody order, and these more recent cases have, and I'm not quite sure why.
So does it seem at minimum that they implicitly determined there was a lack of standing that deprived them of subject matter jurisdiction? The AD?
I'm sorry, I didn't,
The AD dismissed.
right, yes.
So was there at least an implicit finding that there was a lack of standing that deprived them of subject matter jurisdiction to
Yeah,
hear
I
the
mean-
case?
I mean, that's the only reason why I could,
Is standing jurisdictional? Is a lack of standing mean there's a lack of subject matter jurisdiction?
it sounds like they equate the two.
Well, more importantly, I mean, anyone can file a writ of habeas corpus on behalf of anybody else. You don't have the petitioner writ doesn't have to have any relation to the subject of the writ. That's historical practice, right? I mean, if I thought you were being illegally detained somewhere, I could file a writ on your behalf.
Yeah, I mean,
So I'm not sure how standing figures into the writ of habeas corpus at all.
You were the movant for dismissal, correct?
no, that was actually, there were two respondents on this case. There was a respondent grandmother and a respondent father.
Oh, it was the grandmother who moved for dismissal?
Yeah, she moved for dismissal, and the court granted the dismissal. I was surprised also, just as everybody else, that the court dismissed the case. I thought they would have decided on the merits. But the reason I imagine they did it was because of the subject matter jurisdiction issue.
Because they first started it, there was a HABE, there were orders issued or writs issued, and it just seemed like everybody got tired because he wouldn't participate. He stopped participating, that is the father.
Yeah.
And then the case just went away. And then there's a question out there of at least one child that nobody even knows where the child is.
Yeah,
It does
I
seem
mean-
that departmental rule rewards bad conduct.
I mean, that's what happened in this case. However, the mother could have come in and filed a proper custody petition. I'm surprised for all that time that at any point, nobody said, there's
But
no
why
proper
couldn't
custody.
she?
Well, there's a service issue, right?
Well, there became a service issue. But, the way she was awarded service of her writ was by email. So there shouldn't be any reason why she couldn't get the same
But
Didn't
why
we
treatment.
just hear there was a moratorium on custody proceedings? The
Right.
administrative judge placed a moratorium on filing new custody petitions.
I think that was only for about 3 months. I'm not sure.
But
that it was an
doesn't
extended
family
period of
court
time.
convert different proceedings all the time? Even if it was determined by the court below that, well, no, you can't proceed under a HAPE. Family court, they convert proceedings on an hourly basis.
Yeah, I mean, according to CPLR 103C, the referee probably could have converted it. I think she might have been hesitant to do it because since there was no order of custody, perhaps she didn't want to say, well, wait a minute, we don't have in-person jurisdiction, and it might be an abuse of discretion if I just confer in-person jurisdiction on the court without any,
So
without having a proper.
She felt hampered by the appellate division rulings that you had to have a prior order of custody and that no one was looking at what had occurred between grandma and the mom as being that appropriate order?
I think for sure she looked at it and said, wait a minute, we don't have an order of custody, we don't have a petition for custody, so looking at the First Department rule and their case law and their precedent, I can't grant a writ of habeas corpus without an order of
Was
custody.
there ever requests for conversion?
I'm not sure. I don't remember seeing it in the record. I didn't appear as the trial attorney below, I'm not sure.
And absent such a request, there's no sua sponte recognition.
She
Big thing when a
could have.
parent says, I want custody, one would assume the parent has to request it.
Yeah, well, in terms of custody, yes. Yes. Now, in terms of sua sponte, converting it, maybe she could have done it. I'm not sure. I don't know what her state of
Do the
mind
lower
was.
court decisions actually support your position that explicitly that you need a custody order, Chiara and Toussaint? Do you think they're that explicit?
I think so. And because given the fact that the first department ended up dismissing in this instead of hearing it on the merits, I think they relied on those cases to say that, yes, that's it. If there's no final custody order, then there can't be a writ.
So where are my understanding is 2 of the children are back with the mother now, is that correct?
As far as I know, Ms. Khan did investigate, and she...
And then one is not,
One is not, as far as I know.
and we don't know where that child is, and what, suppose we were to reverse, I'm not even sure what that means, what practical effect does that have?
I don't know if it has any effect. I mean, my client, I can't speak for him. I haven't had contact with him. I don't know where the child is. The child might be with him, the child might not be with him. Unfortunately, none of us know. It's an unfortunate situation for the child as well as for, for all the children and for the mother. So I don't know what effect it would have. So in addition, as far as I know Mr. Katz mentioned the parents' patriae obligation of the court to the children, and that's certainly a factor. The court does do things like convert. They do have that. They've done that in the past, and they do it often. But I still think that the family court has to respect the precedent of the appellate division, and they can't just sort of do, well, I have a responsibility to the children, so I'm just going to disregard the first department precedent and just, issue this
But
writ.
all of this seems to me like a justification for converting the habeas petition into a custody. I'm not at all clear on whether that was even asked for. I know it's an item of relief in the mother's brief here, but I suspect, based on what I see in the record, that since Judge Arias had already declared that there was a custody determination, they were doubling down on the theory, we have a custody order. We have a UCCJEA custody order. So, but even so, the court could have done it themselves if they disagreed with that. Why wouldn't that happen as opposed to just a straight-up dismissal?
Yeah, I mean, that's a good question. I think Judge Arias might have been mistaken. I'm not sure. I think she might have thought that was a custody order, because I don't think she would have referred to it. It was pretty clearly a visitation order.
Well, it does say that at the end of the visitation, the children shall be returned to the mother.
Yeah, right.
Strongly suggesting that the mother is the custodial parent.
Yeah, right. That's true. But it's not a final order of custody, and there is a distinction in the law. There has to be. I think what the referee was looking at was the fact that there was nothing that said final order of custody to the mother, which gives me the basis for issuing a writ.
So convert the habeas into a custody and then make that determination.
And maybe she could have, but I still think that she felt constrained by the First Department precedent that said that she did not have jurisdiction, she didn't have subject matter jurisdiction.
And the reason the habeas wasn't an appropriate vehicle for her is why?
Because there was no underlying final order of custody.
So that would exclude most married parents from asking for a habeas, right?
Yeah, I mean, it might. They might have to take that first step. I mean, it doesn't make a lot of sense, but they might have to take that first step of filing for custody, getting a custody order, and then going about it that way, because then there would be an illegal detention.
But I guess what we're struggling with a little bit here is, was that ever requested here?
I mean, I'm not sure. I mean, I'm not sure if the mother had requested that below.
And do you know, and not, if these facts, this proceeding had taken place in South Carolina, and a writ issues without any custody order, and the kids are in New York, would New York honor the writ?
I don't know.
Do you think we would probably want to know that before we allowed this to happen in New York?
I think so. I think the state would have a legitimate curiosity about that. But still, I mean, I still think they should also honor out-of-state, I do think out-of-state jurisdictions should honor the other states' writs. I mean, even if it was, I don't know how closely they would look at it, but a valid writ from an out-of-state.
I don't either.
Yeah, I mean, but a valid writ, if I was South Carolina, I would want to honor it. Same with New York as to South Carolina.
Was the temporary order of custody in furtherance of getting the children before the court back in New York, then the court could render its decision as to custody?
I think I don't really know what purpose the temporary order served. I think they were trying to
Certainly
get
the
them
mother
before
must
the
have
court.
thought, yeah, I'm sorry, certainly the mother is thinking, the court understands these children are living with me and are coming back
Yeah.
to me.
Yeah, I think the family court was trying to do what it could, but I still think or at least the referee had the impression that a petition had to be filed for a final order of custody, and the temporary order of custody would not suffice.
Did the father sign that stipulation related to the mother having physical custody while the grandmother had visitation?
The father, I'm not sure he did. I think he did appear in that matter, but I'm not sure he
Okay,
signed off on
that's
the
what I thought, that's
stipulation.
what I wanted to confirm.
Yeah, yeah. But again, I would argue that that is just a order of visitation to the grandmother. And while it does say that the child is ultimately returned to the mother, it's really not a valid order of custody.
Thank you, counsel.
Thank you very much, Your Honor.
Your Honor, I know I'm out of order to say anything, but in the second department...
I have no objection. Your
If something is said that's incorrect, you're allowed to correct it.
So, Ms. Khan,
As I
hold on,
understand-
just hold on a minute.
Yeah.
Could you come up to the podium so you're in front of the microphone, please?
Oh, I'm
Yes.
sorry.
So you didn't reserve time, but I'll give you a minute.
Okay. I would just ask that you look at Domestic Relations Law 75A3 and 4, which say that a first visitation order is a custody order under the UCCJEA, and a first visitation proceeding is a first custody proceeding. So if there's any question as to whether there was first custody proceeding, the first visitation order to the grandmother is a first custody order to the mother. It doesn't say that the petitioner in that first proceeding has to be the petitioner on the writ. That's all.
So just to be clear, Ms. Khan, your argument here, and I think your argument below, is simply that I don't need a conversion to custody because I have a custody order under UCCJA, under 75A3. I don't need to argue whether a custody order is required for a habeas writ because I have a custody order now. That was the argument below and
Yeah,
here.
but part of the problem is South Carolina warrant squad doesn't see it that way.
We have to deal with South Carolina, but
So that's
I
my
just want to make sure I
problem.
understand what your legal approach was, both here and below. It is essentially that you have a custody order.
Yes.
If I may, Chief.
Yes, of course.
I think you had an answer for us, a purported answer for why the AD dismissed. I'd like you to share that.
Well, because the reason the AD dismissed was I filed my appellant's brief, and then the other side didn't file any briefs. I also filed a motion to asking the appellate division to judicially notice the prior visitation proceeding, because that wasn't a formal part of the mother's writ proceeding. And I felt it was critical that the appellate division understand the foundation on which we were requesting the enforcement writ. Instead of the respondents filing answering briefs, the father's, I think it was the father's counsel, Mr. Calderon, filed a cross motion to dismiss the appeal for lack of subject matter jurisdiction. And I filed a reply, but mainly I was, I felt that since it was all one ball of wax and I had made all my jurisdictional arguments on the motion for judicial notice,
So
I
in the
was a
very,
little
in the
sloppy
very
in my
least,
reply.
in the very least, are you arguing that they improperly dismissed it without full briefing?
I never did, but.
No,
not
no,
only
what
did
I'm
they
saying,
yeah,
they dismissed it.
they dismissed
Now
it
that
with.
you're in front of us,
Yeah.
are you arguing that it was error for the appellate division to dismiss without full briefing?
Yes, and one other thing you should know. The Children's Council never submitted a brief to the appellate division because somehow he wasn't expected to. It was true he couldn't communicate with his clients, but he's told me repeatedly, and the record reflects, that procedurally he agreed with me that the first visitation order was a physical custody order to the mother, and the father had a duty to come back to New York if he wanted to file a modification petition. And he also said in the trial transcript, he said that the father appeared at the allocution and knew perfectly well in the visitation proceeding that the mother had physical custody and the paternal grandmother only got her hour of visitation from the physical custody of the mother. Because you don't get a visitation from thin air. You've got to get it from physical somebody. And if you look at the grandmother's petition, which is part of the record, because it was part of the judicial notice motion, you'll see she specifically says, I, the paternal grandmother, live in New York. The mother and the children have lived in New York at 140th Street for 9 years, and the
Counsel,
father
we have
lives
your
in
point.
South
Thank you.
Carolina.